Law and Sustainable Development Giovanni module. I'm Dario Piselli, Program Manager of the module. Together with me today, Professor Riccardo Pavoni, the academic
Hi everyone, welcome to the third webinar.
And our guest lecturer, Professor Giovanni Gruni, research fellow at the ESADE Law School of Ramon Llull University in Barcelona, and previously associate professor at Leiden University in the Netherlands. I will just give the floor very briefly to Professor Pavoni for a short introduction, and then Giovanni will deliver his presentation on sustainability obligations in the EU free trade agreements. Riccardo. You are on mute, Riccardo. Just asking you to.
Yeah. I will just add a couple of words to what Dario Piselli has already said. We are particularly grateful to Giovanni Gruni for accepting our invitation to be the first speaker for our 2019-2020 webinar series within our Giovanni module on the EU and sustainable development. We're also particularly grateful to him because he's going to speak about a key theme within our overall research projects. The title of his presentation, of his webinar, is Sustainability Obligations in EU Free Trade Agreement. We think that Giovanni is indeed very well positioned to speak about this topic. He has recently published a book with hard publishing on the EU World Trade Law and the right to food. He has worked as a trainee for the Appellate Body of the WTO in the past, and he has undertaken lots of research on the interplay between WTO law, trade law, and other values, such as, for example, human rights values, environmental values, and labor standards. Giovanni holds a PhD in international economic law from the University of Oxford and an LLM from the European University Institute. So thank you so much for accepting our invitation, and the floor is yours.
Thank you very much for inviting me, and thank you very much for the presentation. I prepared some slides. Okay, can you see?
Now, and you should also be able to see them as you present.
Okay, the slides, right?
Yes, I can see that. We can see them well.
Thank you very much for the invitation. My name is Giovanni Gruni. I in Barcelona teaching the course of World Trade Law, and also set up research on sustainable development in international trade law and international trade agreements. So in the presentation, which is going to last around 40 minutes, I'm going to present my research on sustainable development in recent free trade agreements of the European Union. How have I in the first part, I give a general sustainable development and world trade law. So what does it mean? Sustainable development. So I'm going to spend 30 seconds on explaining law in case there is anyone listening who has never studied on. I'm going to start entering details of the topic, which is specific in the free trade agreements of the European Union, specifically recent free trade agreements of the EU, like CETA, EU Mercosur, EU Japan, and I can already say that when we talk about sustainable development in free trade agreement, mainly first one, labor standard obligations for obligations related to the protection of the environment. In the second part of the presentation, I'm going to enter a bit more technical where first I'm substances start to a labor standard environment in free trade agreement of the and or also whenever these free trade agreements do contain obligations on labor standards and environment, and as I will say today, in some obligations, and then in the last part of the presentation, which is critical and constructive, it is more the focus of my recent research. I'm gonna propose an alternative way of enforcing these obligations, which, in my opinion, provides a better enforcement than what is actually in these FTA. Let's start the presentation. What do I mean in terms of sustainable development in world trade law and sustainable development in trade agreements? So law is a very large body of international rules, which started actually just after the Second World War, and has the main objective of regulating international trade of goods and services, but increasingly also other issues such as intellectual property rights. Now, as I said, this body of legislation developed really since Second World War, first with this very first international trade agreement on free movement of goods, the GATT, and then from there developed trade round after trade round, with countries adding more and more to international trade law. Now, as probably everyone knows, the landmark of the watershed in the evolution of world trade law was the creation of the World Trade Organization in 1995, which also started a much more efficient way of enforcing international trade rules via a system of courts, panels, and appellate body. Now, what happened after the creation of WTO? A few years in 2001, round of international negotiations of trade on trade was started inside the WTO, which was called, it's still called the Doha Round. And the idea of this new effort of negotiating trade agreement WTO was actually extending the rules on free movement of goods and services, and also rights, and also discuss some other issues about the institution, with the idea also in the Doha Round of correcting some imbalances of the system, including, for instance, some issues about development, even sustainable development. Evolution of international trade law, if we look at the global perspective, so if we look at the World Trade Organization, for instance, rules have never been designed to accommodate sustainable development, and in particular to accommodate labor obligations or environmental obligations for a number of reasons. In these negotiations, which then led, for instance, to the creation of the WTO, the issue was never really discussed, or whenever it was discussed, countries didn't want to add any rules. Some countries were against the inclusion of labor standards and environmental obligations in the World Trade Organization, for instance, because they were thinking that this could be used as an excuse not to respect other obligations on trade liberalization or property, for instance. There were also a number of influential economic arguments which were very much not in favor of inclusion of labor and environmental standard in world trade law. Now, the result of this, from a legal perspective, is that in the WTO, there is almost no obligation. There is no obligation, actually, on labor standards and environmental protection. States can be member of the WTO without respecting any international rules on environmental protection or even labor standard. There are just some exceptions, like Article 20 GATT, allow these countries to actually double on environmental grounds or standards, but it's no obligation for WTO member to respect any environmental or convention. Now, I make this introduction because this is the context in which actually the European Union is actually modifying international trade law via its what it means. How is the European Union involved in this process? So there are main developments that I want to mention before explaining what the European Union is doing, which actually in recent years are sort of changing a bit what the EU approaches international trade law, and actually are pushing more labor standards and environmental protection in the direction also of European Union trade policy. So first, the Lisbon Treaty. In the Lisbon Treaty, there are articles like Article 21 TEU, which for the first time created for the European Union to include sustainable development in its foreign policy, all aspects of its foreign policy, including Another development was Opinion 215 of the Court of Justice of the European Union, which actually for the time clarified the inclusion of labor standards and environmental protection in free trade agreements concluded by the European Union is covered by exclusive competence of the EU. So this is a major development. This was a major development because it means that after Opinion 215, when the European Union wants to include references to conventions of the International Labour Organization or environmental convention in free trade agreements covered by exclusive competence, which means that the European Union can negotiate the treaty, conclude the treaty, and also ratify the treaty on its own without direct involvement of member states, and also without ratification of the member states. So developments which are linked also with another development which happened in the Doha Round. The Doha Round, as I said, is this very large negotiation which is happening in the WTO. Is not going very well in the sense that there is a lot of disagreement between WTO members. There is specifically a lot of disagreement between Western countries and some larger developing countries such as China and India. The result of this is that in the Doha Round, not much new legislation is being produced, and actually in literature, sometimes we'd even accept that the Doha Round basically stalled or failed around 2005. I say this because this sort of incapacity of the Doha Round of delivering new international trade treaties caused a major change in the trade policy of the European Union, which after 2005 started being much more active in the conclusion of free trade agreements, not in the WTO, but outside the organization, directly with partner countries. Now, this policy has produced already very famous even free trade agreements such as CETA, EU-Japan, EU-Mercosur. But as you see, for instance, from this slide, the policy is very wide. So basically, the European Union is either negotiating or has already concluded free trade agreements with most of the countries of the world. And this is allowed in WTO law by some exceptions like Article 20 GATT and 5 GATT, as the European Union is using widely this option to conclude FTAs outside the WTO. Now, this policy is particularly relevant when we discuss the inclusion of labor standards and environmental standards in free trade agreements, because in all new recent free trade agreements contain a section about sustainable development, which doesn't exist in WTO law, a section of sustainable development, which is a section mainly on labor standards and obligations on the environment. Now, having said that, what I'm going to do now in the next part of the presentation is actually first identifying what are actually these obligations on labor standards and environment included in recent free trade agreements of the EU, so things like CETA, EU-Japan, EU-Mercosur. And then in the second part, I'm going to focus more on the enforcement. So if there is indeed an obligation on labor standard and environment, how is this obligation actually enforced? And then in the final part, as I said, I'm going to make a proposal on actually how to make this enforcement mechanism more efficient, better. Now, first of all, sustainable development obligations in European free trade agreements divided into parts. First part, core labor standards, and the second part, environmental protection. So what do we have in terms of protection of labor standards? Generally speaking, what we have is a reference or obligations to respect the 4 core labor standards, so freedom of association and effective recognition of the right to collective bargaining, elimination of all forms of forced and compulsory labor, effective abolition of child labor, and elimination of discrimination in respect of employment and occupation, which are the 4 core basic labor standards, which are linked to 8 conventions of the International Labour Organization, which actually identify specific obligations on these issues. In the case of CETA and EU Mercosur, we go a bit beyond that in the sense that we do find some obligations also on workers' health and safety, and also on labor inspections. Now, on the quality of these obligations, I'm gonna go back later because there are some issues which I want to flag. But I'm gonna say this later after I mention also what's happening in terms of environmental obligations. In terms of environmental obligations, there is a general obligation of respecting multilateral environmental conventions of which the parties to this agreement are members. There is now recent agreements, for instance, on EU Mercosur, even EU Vietnam. There is a specific reference to climate change conventions and the Paris Agreement with an obligation to implement them. And then there is, and this change depending on which FTA, there is a reference also to other international conventions on the environment. For instance, the Convention on Trade in Endangered Species, but it depends. So the kind of convention which are actually mentioned in FTAs changes a bit depending on which FTA. Now, so there are indeed all these references to these international conventions. Is not the first time that in world trade law trade agreements sort of take inside an FTA legislation from other parts of international law, which were not necessarily only about trade. It has already happened in the WTO with intellectual property. When the TRIPS were included in WTO law, the operation was mainly taking international treaty from other parts of international law about intellectual property and bringing them inside the free trade agreement. And that's exactly what, let's say, the EU is trying to a certain extent to do with regard to environment and labor. Now, these obligations, they do have some issues, so they are not really as prescriptive as you would expect. And I always make an example when I do these presentations in the sense that in international law is generally very difficult. So international law is generally very difficult to enforce for a number of reasons that are very clear in the history of international law. So in general, in international agreement, an obligation to have some kind of legal effect and also to be enforced has to be particularly clear, precise, and unconditional, as we say in EU law, or in general, has to identify something that the state is obliged to do, or something that the state is, for instance, prohibited to do, but there should be something very specific that the obligation says, so that, for instance, other parties to the international agreement can say to the country it doesn't respect the obligation, it doesn't do something, or is doing something which is prohibited. Well, you're doing something which is illegal, and maybe then also start an enforcement procedure. Now, a problem with sustainable development obligations in recent free trade agreements of the EU is that these obligations are not always very prescriptive. So I make 3 examples. So, for instance, these obligations that sort of I made up just to make an example. If you read example number 1, the parties to the FTA shall ratify, implement, and enforce Convention 182 of the International Labour Organization prohibiting child labor. This is a very strong obligation because it refers to the International Convention of the ILO. It also says explicitly that the country should ratify, so ratify in the national parliament, implement, for instance, via domestic legislation, and enforce, for instance, via domestic court. So this is a very strong obligation, but there are very few obligations like this in sustainable development clauses, unfortunately, or depending on what position you take on trade and sustainable development. There is actually often even very large sections of this agreement which are relatively vague, what informally sometimes in my courses I call legal blah, blah, blah. So we say something about labor standards and environment, but there isn't really anything prescriptive. So if you read, for instance, an obligation, a part of legal text like this one, the parties to the FTA reaffirm the importance of the Convention of the International Labour Organization. Well, that's we say something in the FTA, but there is nothing prescriptive. We don't say that the country has to ratify the convention. We don't say it has to implement it. We don't say it has to enforce it, for instance. So that there are some also situations like this in FTAs. There are actually a lot of situations which I call sort of gray areas. So like in the third example, the parties to the FTA shall work towards ratification of the Convention 182 of the International Labour Organization prohibiting child labor. Well, it's not a complete absence of obligation in the sense that we say that there is a sort of best effort that the country should do to ratify. We also don't say that there is an immediate obligation even just to ratify the convention as the FTA enters into force. And actually there are, so in these FTAs, depending on the situation, we find a mix. So sometimes we find some clear-cut obligations. There is a lot of gray area. There's also a good part of legal blah blah blah. So references of to environmental labor, which are not really prescriptive. Now, at the end of this, still we can conclude that there is in recent FTAs of the European Union a direction at least to oblige countries to ratify and even respect core labor standards. So the four core labor standards of the law and some international organization on the environment, specifically the Paris Agreement and the Convention on Endangered Species, for instance, are very generally mentioned, are generally linked with very specific obligations to ratify and also implement. So I just want to give you a couple of examples of what we find in free trade agreements, so that you visualize also examples of these obligations, and then I'm gonna go on with the second part of the presentation on enforcement. So this is an example actually of the EU-Vietnam Free Trade Agreement of an obligation of labor standard, which is actually the obligation on the core labor convention of the International Labour Organization. As you say, the obligation says, make continue and sustain efforts towards ratifying, to the extent it has not yet done so, the Fundamental ILO Convention. So again, in the EU-Vietnam FTA, there is indeed a sort of best effort obligation to ratify this convention. There isn't a very clear obligation to ratify, implement, and enforce this convention. And this is, and it is my opinion, but also the opinion of my colleague Marco Bronkers, who co-written some of this research with me, that actually it would be advisable, so ideally, at least with regard to core labor standards, what we want to find in these FTAs is not a best effort obligation like this one, which is unclear what kind of obligation creates on the state, but actually we would like to see a very clear obligation on the state to ratify, implement and enforce, which actually starts immediately at the moment that the FTA enters into force. Now, another example of obligation is the one which is included on climate change, which is, and this is another example taken from the EU-Vietnam FTA, which indeed says that the parties to the FTA has an obligation to implement the convention, the international treaties on climate change, including the Paris Agreement. Now, so as I said, in terms of substantive content, so in terms of what are the obligations that are created by these free trade agreements on environment and labor? Indeed, there are some obligations on environment, for instance, on climate change, for instance, on endangered species. There is sometimes something else on fisheries as well. And there is generally obligations on core labor standards, even if, as I said, even there, like in the example of the Vietnam FTA, they're not written in a most prescriptive way. Still, compared to WTO law, certainly there is a direction which is given to the legislation in terms of inclusion of more obligations on environment and labor. So this is the situation in terms of substantive content, so the level of protection which is given. Now, in the last part of the presentation, I'm going to talk more about enforcement. So once indeed we can find an obligation on labor or environment in these free trade agreements, how is this obligation enforced? And then in the second part, in the very last part, I'm going to actually make a proposal on how to actually improve these enforcement mechanisms. So, what is the situation now in recent free trade agreements of the European Union? So, how are these obligations enforced? So, there is indeed some kind of enforcement mechanism, but the starting point is that enforcement mechanisms which are there in the treaty and are used to enforce economic obligations of the treaty, like free movement of goods, services, even intellectual property, cannot be used to enforce sustainable development obligations. So every FTA of the European Union actually contains a specific clause saying that the general dispute settlement mechanism of the free trade agreement, so this panel of trade experts which are used to enforce the economic obligations, cannot be used to enforce environment and labor standard, and then a separate, softer, weaker enforcement mechanism is then created. The details of which I'm gonna explain in a few minutes. Before that, I just wanted to briefly explain how the enforcement of the free trade agreements works in general. So not for sustainable development obligations, but for obligation on free movement of goods and services, or for intellectual property. So what is the general this general enforcement mechanism and dispute settlement which is provided for economic obligations? So there are two general phases. The first one happens completely EU level. So it's actually done via European Union regulation, which is called trade barrier regulation. And is actually today, this EU level, the only way for private parties, companies specifically, to have access to the enforcement of obligation in free trade agreements indirectly. And I'm going to explain how this works. So there is this trade barrier regulation at European Union level. So this is something that happens domestically. We are not yet in the international dispute settlement. A company can file a complaint to the European Commission in case thinks there is an alleged violation of an obligation a third country has on the basis of European Union free trade agreement. For instance, of free movement of goods, for instance, on market access to services, or even intellectual property. Now, on the basis of this complaint, the European Commission starts an investigation, can also involve the third country, and then makes a conclusion on the existence or non-existence of the violation by the third country, publishing a report. And then with the publication of the report, with the Commission publishes the conclusion of the investigation, identifies, clarifies if indeed there was or there was not a violation of the obligation in the free trade agreement. On the basis of the conclusion, the European Union can then take some actions vis-a-vis the third country. Now, in a situation at this sort of EU level, first investigation of the Commission, started by a private actor, doesn't work, then indeed, one of the possibilities for the European Union is starting the enforcement mechanism in the free trade agreement itself, which is in the form of a dispute settlement mechanism. It always starts with formal consultations between the European Union and the third country. So, for instance, if the European Union thinks that Canada is not respecting some economic data, can ask for formal consultation with Canada. And the idea is try to discuss the problem, but also try to find an amicable solution. If this doesn't work, then indeed there is a litigation phase where the European Union can actually start a legal action, start a lawsuit against the other country. And in free trade agreements of the EU, this is aired by a panel of trade experts, which then publish and issues a report on the violation, where it identifies legally if indeed the country has not respected the free trade agreement. If this litigation is done via the WTO, there is also an appellate procedure via the Appellate Body. Now, what happens if this panel is this sort of international court which is embedded in the free trade agreement, it finds indeed a violation of the free trade agreement by the country, and the country doesn't do anything? Well, with regard economic clauses and intellectual property, it's also possible to impose trade sanctions, to actually dissuade or force the country into respecting the free trade agreement, generally in the form of, for instance, of the imposition of retaliatory tariffs or compensation. So there is the possibility also of imposing economic sanctions in the third country. So now again, this is the situation of enforcement of an economic obligation contained in a free trade agreement of the European Union. This is not the case for environmental and labor standard obligations, because even in recent FTA of the European Union, first of all, the trade barrier regulation cannot be used to enforce labor standard and environmental obligation. And then in this new free trade agreement, as I said, the general dispute settlement with this litigation that also can lead to sanctions cannot be used to enforce environmental and labor standard. What indeed we have there are a formal consultation and a sort of form of litigation where a panel of environmental expert, of labor standard expert is created to assess if there is a violation. Now, if after the publication of the report, the country still doesn't respect the obligation of the environment and labor, there is no way in these recent FTAs to do something which is done in economic obligation, which is, for instance, imposing economic sanctions in the form of trade sanctions. Now, this is what is the situation. So it's a more descriptive part of the presentation. What I'm going to do now, I'm going to present an alternative proposal, which I wrote together with my colleague Marco Bronkers, who is a professor at Leiden University. And the objective of this proposal is actually giving sustainability obligations the same exact enforcement quality as it is given to economic obligations and intellectual property obligations. Now, this last part of the presentation is going to be more focused on labor standards, because that's the only part we have already published, and we're actually in the process of writing the part on environmental protection. And actually, just a few days ago, we published on the Common Market Law Review the result of the research on labor standards. And as I said, we are in the process of actually converting this and developing it also on environmental clauses. So there is a discrepancy. This discrepancy in enforcement between how economic obligations are enforced and how environmental and labor standard obligations are enforced. Now, I'm making now an example of an alternative way of enforcing it with regard to labor standards, which would solve most of these issues. So the proposal actually is divided in two parts, which is the two parts of enforcement as they exist today in European Union international trade law. So first of all, what we propose is to reform the trade barrier regulation so that it can also be used to enforce labor standards when included in free trade agreements of the European Union. That's I'm going to explain how we want to do so. And then the second part is also reforming the dispute settlement with regard to standards in free trade EU so that the general dispute settlement of the FTA can also be used to enforce labor standards. And also we think that we should have economic sanctions, and even at a sort of extrema ratio also trade sanction. I'm going to explain how this is going to work. Now, actually the new commission has the objective, as you already stated, the objective of wanting to reform the trade barrier regulation, and we do think that in the context of the reform we could give better enforcement to sustainability obligations. So first of all, how do we want to do this? In the case of labor standards, an example, we think that we can identify a group of representative social partners, so representative trade unions and employee organizations, which would be given the legal standing not to start a litigation in the FTA, which would be left to the Commission, but to start actually to file a complaint under the trade barrier regulation whenever there is an alleged violation of labor standard. What do I mean in terms of representative social partners? Identify them, because in Article 154 of the TFAU, there is already a reference to representative social partner. There is already a system inside EU law with regard to legislation which actually allow us to identify trade unions, labor organizations, and also employee organizations which are particularly representative at European Union level. So we do think that the same list of representative social partners can be used. Them should be given legal standing in the TR of obligations. In addition to this, advisory groups, which are groups of social partners, but also some NGOs, which actually created in the context of European Union free trade agreements to monitor the implementation of sustainability chapters. We do think that actually these domestic advisory groups should also be given a more formal legal standing with regard to the TBR. Actually, there is in the history of European Union trade law already an attempt in the case of South Korea some years ago to actually ask to the Commission to enforce a labor standard obligation in the EU-South Korea FTA. This domestic advisory group, not having formal legal standing, actually basically to wait for the totally discretionary position of the Commission, which in that occasion some years ago didn't start actually any litigation against South Korea, even if now recently an action was actually started. Now, so these representative social partners, we think, should have a legal standing in a trade barrier regulation. So the trade barrier regulation should be also reformed to accommodate sustainability obligations. Of course, there is a need to sort of filter out frivolous complaints to avoid that the Commission is going to be sort of is going to drown or is going to receive too many complaints. But there are ways to do this legally very easily. Some of them are already in the TBR. First of all, the complaining party should demonstrate that the EU has a right of action, so there is a clear obligation for the third country in the free trade agreement. We don't think actually there should be any need to demonstrate the link with trade, so we do think that this should be an enforcement mechanism based only on the alleged violation of the labor standard without the need of demonstrating any link with trade. I say this because in some US free trade agreement, actually, there is this also need to demonstrate the link with trade, which is almost impossible to demonstrate. It actually makes the entire enforcement mechanism basically useless. So, trade barrier regulation, the Commission receives the complaint from the private party, starts an investigation. It can happen that indeed the Commission finds a violation of the labor standard, and then what can happen is that maybe the third state solves the situation, or maybe the third state finds some kind of agreement with the European Union to solve the problem, or maybe the European Commission, via this internal investigation, doesn't find any violation of the labor standard contained in a free trade agreement. So that's also something which sort of the story ends there. Indeed, there can be also the situation where the Commission does find a violation of the labor standard, and the third country doesn't do anything to actually solve the problem, doesn't do anything to respect the obligation, then indeed we do think that the option would be to move to the international dispute settlement in the free trade agreement itself. So again, consultation and then litigation phase against the country. We do propose in this paper we have just published on the Common Market Review, and actually you find the link at the beginning of the slides, that we should reform part of the procedure. For instance, we do think that we should include also economic sanctions in the case the country keeps not respecting the labor standard obligation, even after the panel has found actually that there was a violation. Now, we do think that we would start via economic sanction and fines, and actually in the paper we propose a system which is similar to what actually is used in the European Court of Justice to calculate the amount of the fines which has to be paid by member states when not respecting EU law. We do think that a similar system actually could be used by this panel in FTA to define a fine that the country has to pay whenever not respecting the specific sustainability obligation. In the case this doesn't work, only in this situation, as real extrema ratio, we do think that also trade sanctions should be available as they're available for the enforcement of economic obligations and intellectual property. For instance, we could think that the same amount as the fine is actually then imposed as a retaliatory sanction against the third country. So, to sum up the entire presentation, there are new obligations about sustainable development in free trade agreements of the European Union. They're both about labor standards and environment. There are problems in how these obligations are written, and actually whoever is working on these issues, my suggestion is always that first to develop the skill whenever reading these sustainable development clauses of being able, for instance, on the basis of the presentation I made before, to identify exactly when actually these FTA contain obligations and when instead it's just something about labor and environment which doesn't have any legal significance. And then I also talk about the enforcement of the FTAs, identifying actually the discrepancy and the weaker enforcement which is given to environmental and labor standards. And then I made a proposal more focused on labor standards. I'm now developing also for environmental obligations on how this discrepancy can be solved, and now we can give the same enforcement to environmental standards and labor standards as we give to the other economic obligations. So, having said that, this is the end of my presentation, and thank you very much for your attention. And as I said at the beginning of the slide, I made references of all relevant publications. In particular, on the enforcement proposal, I have a publication out a few days ago on the Common Market Law Review. Thank you very much for your attention, and I'm looking forward to receiving your questions.
Thank you very much, Giovanni. Let me remove the screen for the moment, and then I will bring in Professor Pavoni again, asking him to unmute. It is also time for questions, so if anyone wants to type their questions in the YouTube, on the side of the YouTube video, they can do that. But first, maybe I will start with some points by Professor Pavoni, and then I can also maybe ask a few questions myself. Riccardo.
Well, no, I just have a very general comment on Giovanni's presentation, which I really appreciated. I think this is very timely, and it really provides us with food for thought. I mean, we are rethinking about these issues at the regional level. Well, my thought was this. I mean, of course, there's a lot of discussion about this continuous proliferation of regional free trade agreements, led by certain countries or certain economic blocs, such as the EU. In the past, there have been lots of discussions and criticism about this proliferation outside the WTO framework. So there was this kind of trend of viewing regional free trade agreements as a sort of derogation from multilateralism in the WTO, etc., etc. Well, actually, my impression, and I think this impression is reinforced by Giovanni's presentation, is that these regional free trade agreements, at least in the case of the EU, can be beneficial to this area of the law, because they are bringing reforms in line with a more holistic view of international law, where trade law is just not about trade law, it also includes sustainability obligations. And now the challenge is that of providing an enforcement mechanism which is at the same level as the enforcement mechanism of trade obligations. So I'm just wondering whether Giovanni agrees with this view, whether regionalism is really beneficial to multilateralism in this case. And of course, in the what stands in the background is the stalemate at the WTO level, as you know, which we really don't know what will happen with the WTO in a few weeks. So I would like just to hear Giovanni's views on this.
Thank you very much. Giovanni, if I can add just a very tiny point to this, because I wanted to ask something that was actually linked. Because in one of your recent papers, which I think was about the common commercial policy after opinion 2 of 2015 of the European Court of Justice, you stress that for some reason the approach to the negotiations of the EU is a bit different when it negotiates FTAs with respect to when it is at the WTO table. For example, for the trade and services agreement, it seemed that there's not the same level of ambition in the way that it is approaching the table. So maybe this links to what the professor was saying, like what do we make of this?
Yes, okay, thank you very much. So I'm going to answer the two questions separately. Now, the debate on free trade agreements, are they beneficial to multilateralism or not, it's very much an open debate, and I don't address this issue in the paper. Now, there are two positions. The first one is that this is undermining WTO, also in terms of dispute settlement, because some people say all this litigation that we have in WTO is going to slowly move towards FTAs, and then the WTO is going to become more relevant. Now, this hasn't happened yet, but this is a position. There is another position, which is actually people saying, well, you know, we include all these standards in these free trade agreements, and then these standards, which will be already there in FTAs, one day we're going to also multilateralize them in the WTO. And then actually a sort of, say, beyond the law, a geopolitical strategy also to win the opposition to certain standards by China and India mainly. So that's something which is also happening. Now, is a matter of fact that with regards to sustainable development, we are having some development in international trade law which have been impossible to achieve in the context of the WTO. And this is happening also because the European Union has generally more leverage in the trade negotiation, taking country one by one in FTA negotiation than in the context of the WTO. And then now I also link maybe to the second question. Indeed, my opinion is also the European Union is much more careful in putting forward sustainable development proposal in the WTO than in FTA context. Also because probably is much more difficult to achieve them in the WTO context. I mean, if you look at the history of international economic law, I think even Bill Clinton tried to make the proposal during the famous Seattle Ministerial Conference to have a social clause in the WTO. There was a lot of opposition by developing countries, especially. So that's something really very much difficult to achieve in a WTO context. I don't know if I answered.
Yeah. This was pretty impressive, and I do share your views here, and. Much will depend on the enforcement mechanisms. I think that's really the next challenge, and I think you really focused on the key point here, enforcement mechanisms, because if these obligations will not be presided by a strong enforcement mechanism, then they will have certainly that they will be weaker, or at least mere reaffirmations without without being capable of being enforced.
Sorry, Professor, if I can add something on this. Since you mentioned the enforcement mechanism, something that I wanted to say during the presentation and I forgot. It's true that this discrepancy with a weaker enforcement mechanism given to environment and labor in FTA of the EU, that's a reality. However, if you look at the broader landscape of international trade law, it's already happening, for instance, in the CPTPP, that there is already the same enforcement, the same dispute settlement that can be used for economic obligations, can also be used for labor standards and environment. And actually, the CPTPP model, which is actually to use in the same dispute settlement, could be in principle used also for European Union FTAs. The CPTPP actually has a clause, a procedural clause, which has explicitly, we use the same dispute settlement, but whenever there's an issue about environmental labor, we just want to have environmental expert and labor expert as member of the panel, but then the procedure is exactly the same. And indeed, if the European Commission changes its stance on enforcement, because now the European Commission is, let's say, very much against or adverse to giving the same enforcement to environmental and labor obligation as economic obligations, then yeah, I would say that the countries which already have concluded the CPTPP might also be willing to include it because they already have it in the CPTPP context. Sorry for the interruption.
No. What is this what is this agreement, CCPT?
So the CPTPP is the comprehensive and progressive agreement for a Trans-Pacific partnership.
The Trans-Pacific.
Which is the new agreement which has substituted the TPP, the Trans-Pacific partnership, once the United States left with Trump. Now, in this CPTPP, which is actually already a done deal, there are some countries with which the European Union already has an FTA, like Canada, Chile, Japan, Peru, and Singapore. And also there are countries with which the European Union is either negotiating or in the process of concluding an FTA, like Australia, Mexico, New Zealand, and Vietnam. So these countries already have an FTA with someone else with an enforcement procedure, which is the same as economic obligations and intellectual property. So once, let's say, the Commission was to be more ambitious and actually try to include the same enforcement, say, yeah, maybe this country will be willing to discuss it.
Okay.
Super. Okay, maybe can I jump in here? I have maybe a couple of other points. I see that there are still no questions on the right side panel. I emphasize that our viewers can ask questions as they indeed usually do so. Now, I wanted to follow here on enforcement actually, because I think I make reference to the same paper that I was quoting before. And I found it really interesting to read the account that you make of, and you also mentioned it in your presentation, of the problem of standing of private parties in the context of these enforcement procedures. And of course, you mentioned that the European Commission has kind of failed to sort of borrow other models, especially the North American model of trying to give standing to at least, albeit difficulties to some private parties. And I was wondering if you think that this is due to what you also mentioned in the paper, that is, kind of a bit of deference to the relatively conservative position of the European Court of Justice on sort of, the possibility of the justiciability, let's say, of these issues at the level of international law rather than by the court itself, or if there's another reason for this kind of timidity.
There are several reasons why this is not happening, but I disagree with them. So I disagree that we should keep the discrepancy between enforcement of labor environmental standards and other obligations. Now, something I want to stress is Opinion 215 of the Court of Justice of the European Union. We are not talking anymore in general about environment and labor as something which is, maybe it's going to be a shared competence, maybe it's going to be a part of international law. whenever is an environmental labor standard clause in a free trade agreement of the European Union, this is part of the common commercial policy of the EU, and this part of an exclusive competence of the European Union. And so in my opinion, we should just treat these obligations and any other obligation on trade that we have in free trade agreements. With regard to the issue of legal standing of private parties, indeed, now it is an issue because private parties, they don't have access to dispute settlement internationally. And actually, my opinion, and also the opinion of my colleague Marco Bronkers, is that we shouldn't give to a trade union, for instance, or an NGO, a direct access to dispute settlement. Also because practically it would be almost impossible to do, because these litigations are very expensive. So what happens, for instance, in investment arbitration is very difficult in practice to reproduce with regard to labor standards and environment. And that's why in our proposal, we do think that we should open the legal standing, we should give access to enforcement to private parties, but via the TBR, with this regulation at the European Union level. And so then private parties would indeed have access to some kind of enforcement, but via this investigation of the Commission. Once the Commission has written this report in the TBR, which happens completely at domestic level, if the Commission has found a violation, it would be very difficult politically for the Commission indeed not to take the issue on board and start also litigation on the FTA. Actually, but this sort of two-pronged system we designed with the legal standing in the TBR, and then the Commission representing the EU in the free trade agreement dispute settlement, in our opinion, is ideal because it's affordable and also can actually ensure enforcement of these obligations. I don't know if I answered the question.
Of course. Yeah. This is very clear. And of course, there's also the problem that, of course, if you accept the principle of direct access by private parties to the dispute, like for example, a trade union, then of course the same would be should hold true for the trade parties. I mean, for example, a company should be given direct access to these enforcement mechanisms as well. Otherwise, you reproduce the same problem of the lack of equality of arms, no?
Yes, but that's why we start from the TBR, because companies already have. In any case, in the reform TBR, what we say in the proposal is that representative social partners, which actually include employer organization, as well also labor unions, should all have actually access. And actually, via the domestic advisory group, there's also space for labor unions and employer organizations, together with some NGOs, also to discuss the issue before actually bringing the case. So indeed, I do agree that the private access to this kind of enforcement should be extended not only to trade unions, but also actually to companies. That's something I completely agree. But it's already a case in the TBR. Companies already have access.
Okay.
Super. Okay, I think we have, just a couple of more minutes, and I unfortunately see there's still no questions, so maybe there will be no space for questions from the audience today. But I don't know if Riccardo has any further point. Otherwise, I had one last curiosity that I wanted to sort of raise with Giovanni, and then we can sort of close it up.
No, I just wonder whether Giovanni can tell us about the European Commission's position in a few more detail. I mean, what are the reasons why the European Commission is against even creating the same dispute settlement mechanism for sustainability obligations vis-à-vis trade obligations?
So I can refer to two non-papers published by the Commission in 2007 and 2008. So I will talk mainly about the last one, which is the one in 2008. And actually, if you check on the Common Market Law Review publication, the most recent, which is the link at the beginning of the slide, actually I think footnote 9 refers to both publications. Now, in this non-paper, there is a clear position of the Commission against giving the same enforcement of labor standards and environmental obligation as is given to economic obligation. One reason, I think, is because the Commission thinks that having a softer enforcement helps in negotiation to actually achieve better obligations and on these issues. I think this statement is debatable, first of all, because these obligations on labor, they do have problems on their own. And also, if you compare with the CPTPP, well, the CPTPP, which has an enforcement mechanism which is exactly the same, does contain, for instance, core labor standard. They're very clearly stated. I think there is also something about health and safety, which is generally not included in agreements of the EU. So this first part of the argument, I don't think is defensible. Another reason, I think, is because there is a difficulty in actually calculating the amount of the economic sanction that should be actually imposed in case an economic sanction had to be imposed. But that's something we solve in the paper as well. I mean, as I said, the Court of Justice of the EU already imposes fines to member states in case of no respect. So there are ways to calculate these fines, and the same can be used for consider the GDP of the country or the type of violation. This can also be used. So that's my position, and it's different from the position of the Commission.
Okay, very clear.
Okay, super. Okay, just before closing, I seriously, I mean, maybe a 30-second answer on this. I'm very curious about, you know, the sort of emerging debate. I mean, actually emerging for quite some time now at the EU level on the use of border carbon adjustment measures as a way of essentially trying to push the EU trade partners into a sort of bold implementation of the Paris Agreement. And I'm very curious whether you see the use of border carbon adjustment measures as something that you think it will become like much more concrete that the level of discussion that we're having now, and if so, if you think it will be more of a matter of unilateral kind of measures, or if the EU will try to raise the issue in the negotiations of its FTAs going forward.
So this is not at the moment part of the research I'm conducting, but it's going to be part of the future of the research. So I will be a bit more general. So of course, this is going to become a major issue together with the one of sustainability obligations. It's a different issue. So the carbon adjustment measure, of course, international trade law is relevant, because if you do it, it means that you have something in the free trade agreements which allow you to do it. So, and it's actually a question, there are publications published that I can refer you to if this is actually something which would be legal in WTO law, and also going forward, if this is a direction, of course, it is something that the European Union has to take into account.
Super. Yes, thank you so much. It was just a general curiosity with which to end, precisely as COP25 is starting in Madrid, and I think I speak also with Ricardo, but I will give him the floor for a minute to thank you, Giovanni, for taking the time. I'm sure if there are any more questions, they can refer to our email address or be in touch with you. We'll make sure to upload the slides under the YouTube video and also on our channels, including also the papers that you refer to. We will link to the papers, and no, we actually falls within our mandate to try and disseminate this research of utmost interest in the field of EU law and sustainable development, and again, very, very happy that you accepted to be here today, and we of course look forward to communicating the next few webinars to our audience. Ricardo.
Just really a couple of words, because we don't want to abuse Giovanni's time. Just to say that we are very grateful to him, because I think that his webinar is a precious addition to our activities on a such timely topic. So thank you so much, Giovanni, and we hope we have further opportunities for collaboration in the future with you.
Thank you to you. Thank you very much for the invitation.
So thanks to everyone again, and see you all very soon. Bye.